Let me turn this over then to the defense. Does the defense have any witnesses that you'd like to call at this time?
Your Honor, before we present our case in chief, we have a motion that we would like to present to the court.
You may.
Pursuant to Federal Rules of Criminal Procedure, Rule number 29, viewing in the light most favorable to the non-moving party, which is the prosecution in this case, there has not been enough evidence provided that a reasonable juror could find Mr. King guilty of either charge they have charged him with. Specifically, Your Honor, Mr. King was attacked in the middle of the night by a man wearing a mask and carrying a gun. As a result, this man ended up being the fatality in this attack and wrestling match that ensued. One of the elements in order to prove that in murder in the second degree is intent. The prosecution has presented no evidence that Mr. King intentionally killed this masked man on his front lawn that morning. For this reason, the defense moves for a judgment of acquittal.
Any response?
Certainly, Your Honor. In the light most favorable to the non-moving party, in this case, the people have established a prima facie case. Counsel spoke about intent. Well, one of the proposed instructions is that intent can be formed in a moment. And the people had put on Edith Morningside, who testified that she watched a well-lit front yard, and she watched across the street from her house as the defendant pointed a gun and pulled the trigger. We've also heard from Detective Wardinsky and entered an autopsy report that shows that that bullet wound to the back of the head was the cause of death, and that death was instantaneous.
And since it's the defense motion, I give you an opportunity for reply. Any final reply?
My final reply, Your Honor, is to consider the bias that Mrs. Morningside had. Mrs. Morningside says that she saw Mr. King standing over Mr. Cashman and shoot him in the head. However, she witnessed this from 156 feet away. She was on the phone when she was observing what was taking place at a distance from her. And she has an enormous bias against Mr. King for the result of what happened to her husband because of a vehicle that she bought from his dealership.
Let me ask Ms. Jones, if I consider the bias, wouldn't I then not be viewing the evidence in the light most favorable to the prosecution?
No, Your Honor, because the consideration of the bias would demonstrate that the prosecution has failed to demonstrate intent in this case.
At this point, the standard, I think, is clear. Both, and Ms. Jones, you properly cited that in regard. People referenced that as well. The court's required to view the evidence in the light most favorable to the people, draw all fair inferences and assumptions in their favor to determine whether a reasonable juror could find, based on the evidence, that each of the elements have been proven. At this point, looking at the evidence in that light, I'm going to find that given the testimony by Ms. Morningside that her husband, excuse me, not her husband, that her neighbor in that regard, had stood over the body, and made a statement that nice try, and taken a moment and collected his thoughts and fired the gun. Given the location of the wound and the testimony from the medical examiner, I'm going to find that there's been a sufficient prima facie case to submit I'm getting ahead of myself. To submit the evidence to a jury if necessary, so there's a sufficient basis to proceed with the trial. I'm going to overrule at this time the motion for a directed verdict and for judgment of acquittal, and allow the defense to call their first witness.